Mr. Danson, I know I pre-authorized basically a 10-minute opening remarks for you today. So if you want to start now, it would be appreciated. Thank you.
Thank you very much. Thank you for inviting me to appear before this committee today on behalf of the families of Kristen French and Leslie Mahaffey, who I've had the honor and privilege to represent for the past 30 years. Appearing in public to speak to these issues is simply too painful and emotional for the families, and they have asked me to speak on their behalf. My representation of the families over the past 30 years informs the opinions that I'm going to share with you today. This includes guiding them through the criminal justice system, Bernardo's trial, battling the media and certain members of the public who unsuccessfully tried to gain access to the Bernardo Homolka videotapes. This was an enormous undertaking. This was an enormous undertaking, which itself included the need for me to painstakingly review the videotapes and prepare a chart describing every frame of the videotapes and the corresponding words. This fact alone is perhaps the most significant fact that will inform some of the opinions that I give today, and perhaps answering some of your questions, because that was a very difficult process in reviewing the videotapes. This was necessary for the particular argument that we advanced at the time of the videotape motion. We were also involved in the resolution of the plea resolution involving Karla Homolka. Our efforts to have Karla Homolka's plea resolution set aside because we believe that she breached it. Dealing with a little-known potential plea bargain for Paul Bernardo to second-degree murder, which we stopped, even though it would have avoided the trial altogether and avoided the excruciating videotape issue. We were involved in the successful gating application to keep Karla Homolka in jail for her entire 12-year sentence. We went to Joliet, Quebec at the conclusion of her sentence to impose post-sentence conditions on Karla Homolka pursuant to Section 810.1 and 810.2 of the Criminal Code, where during that particular process, Karla Homolka chose to stare me down in court, and where I saw for myself the evilness in her eyes 12 years later, which was identical to what I saw in the videotapes. We were involved in the appeal processes. We were involved in the bone-chilling discussions we had after Bernardo was convicted and had exhausted all of his appeal routes that led us to obtain an order to destroy the videotapes, the crime scene pictures, the autopsy photographs, the steel circular saw that he used to dismember Leslie Mahaffey. We had everything destroyed. And now we're involved in Mr. Bernardo's parole hearings. We're currently before the Supreme Court of Canada with the assistance of the Toronto Police Association on a leave application regarding the family's Access to Information Act request for the records of Paul Bernardo and other offenders who murdered police officers, which they rely upon to persuade the parole board to grant them parole, and what Corrections Canada and the parole board need to discharge their legislative public safety mandate. As I have said just a moment ago, all of this will inform what I have to share with you this morning. But I know this: on these issues, the public interest and the victim's interests are fully aligned. But for the grace of God, go I. With the exception of a public loony campaign 30 years ago, which I had nothing to do with, all of my work for the families has been and continues to be pro bono. Helping these families free of charge is a far greater reward than all the money in the world. And the families wanted me to share a number of points with you. First, all they seek is justice. They don't seek revenge. They don't seek retribution. They accept that Paul Bernardo is entitled to full constitutional protections, the right to be presumed innocent, the right to a fair trial. He got both. They accept that Mr. Bernardo is entitled to humane treatment in jail and that he has a right to seek release on parole. The question, though, that must be answered is, what is justice for a convicted, sadistic, sexual psychopath who committed the most unspeakable crimes known to humankind and who was sentenced to life in prison and additionally designated a dangerous offender? An offender who, after 30 years in prison, right up to his transfer, as found by two different panels of the parole board, had no remorse, no empathy, no insight, and was not treatable. I wish all of you could see, and this is part of our application before the Supreme Court of Canada, even listen to the audio recording of Paul Bernardo's testimony. It would go a long way in people understanding who this person is. In designating Paul Bernardo a dangerous offender, the learned trial judge, one of the most distinguished and experienced judges in the country, Associate Chief Justice Lesage, as he then was, later became our Chief Justice, recounting the unspeakable sadistic brutality Bernardo inflicted on two innocent, defenseless teenage girls and so many others, said this to Mr. Bernardo, quote, "You require jail, in my view, for the rest of your natural life. You are a sexually sadistic psychopath. The likelihood of you being treated is remote in the extreme. For offenders like Paul Bernardo, the overarching principle must be maximum punishment in a maximum security penitentiary. The Supreme Court of Canada tells us that sentencing is the means by which society communicates its moral values. These types of offenders can still obtain the benefit of programs offered by maximum security federal prison in maximum security federal institutions. They're still entitled, as I say, to the regular parole hearings. But never should such an individual be rewarded with a transfer from maximum security to medium security when at the time of the transfer, the offender still showed no remorse, no empathy, no insight into his crimes, and the medical evidence was that he was beyond treatment. It sends the wrong message. It sanitizes the full brutality of his unspeakable crimes. It's no answer that the perimeter security is the same as a maximum security, or that medium security offers better treatment programs for a person that cannot realistically be treated, or by giving him more freedoms and privileges in medium security because he might be more manageable. Offenders like Paul Bernardo, who commit the most unspeakable crimes known to humankind, must receive the most severe sentence our legal system permits. That means spending the rest of their lives, the rest of their natural lives, in a maximum security institution. When Leslie Mahaffey and Kristen French took their last breath in utter horror at the hands of Paul Bernardo, upon conviction, the only rights he has left is to remain alive because we don't have capital punishment. And I don't believe in capital punishment, but that's one right he has, and to spend the rest of his life humanely in a maximum security federal penitentiary. The second point the families wanted me to bring to your attention is this. They have this question. Upon Mr. Bernardo's transfer, the Prime Minister of Canada, the then minister responsible, and I believe other political leaders properly described the transfer as both shocking and incomprehensible. Not my words, not the family words, the words of the Prime Minister and the minister. Canadians were instinctively outraged. It offended all ethical and moral standards, and it was wrong. Even if Corrections Canada followed the rules, which I have a lot of issues with, but assuming it complied with all the rules, complied with all the laws, how can something, this is the question the families have, how can something that is shocking and incomprehensible remain the law of this great country? If it's shocking and incomprehensible, then change the laws. This is exactly what leads to public cynicism and disrespect for the administration of justice and the rule of law. I will never forget, after the first day of argument on the videotape issue, a discussion I had with Donna French. The courtroom was packed. There was an army of media lawyers. Everybody's robed up, very official. There was motion records, factums, endless books of authorities piled up on counsel's table. Yet Donna French cut through all of this and said this to me. I don't understand. We have a right to protect the dignity and memory of our daughter. Some things are right and some things are wrong, and this is wrong. And she was right. And this equally applies to Paul Bernardo's transfer. It was wrong. And this takes me to the family's third point. In practice, and I've been doing this for 43 years, in practice, the system treats most offenders the same. And we submit to you that you cannot treat offenders who receive fixed sentences the same way that you treat offenders who receive life sentences and additionally, in Bernardo's case, an indeterminate sentence because of his dangerous offender designation. There is no cure for psychopathy, worse for sadistic sexual psychopathy. That is a medical fact. If the public knew that there were tough but just laws for Canada's most dangerous offenders, they would embrace the full panoply of treatment and rehabilitation programs for the overwhelming majority of federal inmates. This kind of one-size-fits-all criteria, mechanically checking the boxes, cannot apply to Canada's most dangerous offenders. There must be a separate law for these people. Only this way will Canadians have confidence in our justice system and embrace treatment programs for the vast majority of offenders. The fourth point they wanted for me to communicate to you is this. The reliance on Section 28 of the Corrections and Conditional Release Act and the requirement that the choice of penitentiary must be the least restrictive for offenders is completely misplaced. This is appropriate for the vast majority of offenders who serve fixed sentences, but it is not appropriate for people serving life sentences for murder and or have indeterminate sentences because they've been declared dangerous offenders. This distorts the sentence itself by substituting punishment for leniency, and this may be better for the parole board rather than administrative decisions. But really, in my experience, this least restrictive principle has been more aptly applied to NCR offenders. The fifth point they want me to communicate to you is this. One of the justifications for the transfer was that Paul Bernardo did not represent a threat to attacking prison guards or other inmates. This cannot be a criteria for offenders like Paul Bernardo. These types of offenders, these types of sex offenders, they're cowards. Paul Bernardo is a coward. He would never attack a prison guard or another inmate. He would only attack innocent, defenseless, vulnerable teenage girls and young women. So this criteria must be eliminated for offenders like Paul Bernardo. The sixth point is...
Mr. Danson,
Yes?
could I stop you there? We're much over our 10-minute allotment that I allowed you, so I don't want to cut short some people's questions, and I'm sure they're going to get to some of the information that you're addressing.
Point of order.
No problem.
Sure. If Mr. Danson's getting to his final point, perhaps there's unanimous consent to let him finish.
Thank you, Mr. Danson. The committee would like to see you continue, so let's continue. Thank you.
Okay, I'll do one more point, and I'll leave the last two for hopefully questions. But the last one, because it deals directly with a criticism that we have with respect to justifying the transfer of Mr. Bernardo on the basis of his recent full integration with other offenders on his range, is stunningly weak and completely detached from the sheer sadistic brutality of his crimes. That range in maximum security is very limited. Further, and I think the committee, everyone knows this, the hallmark of psychopathy, of psychopaths, is that the offender is cunning, deceptive, manipulative, a liar, callous, glib, grandiose, narcissistic, and often intelligent. This was the expert evidence before Associate Chief Justice Lesage at the time of the trial and the dangerous offender application, and this is the evidence before the parole board. So these type of offenders learn how to manipulate the system and the various tests that are being applied to them, and they learn from test to test. So therefore, there just has to be a different criteria to be applied to these individuals. And thank you for the extra time, and I'll happy to take your questions.
Thank you, Mr. Danson. We're going to start with questions with Mr. Shipley, please, for 6 minutes.
Thank you, Chair, and thank you, Mr. Danson, for being here today, and thank you for your patience with trying to get scheduled in with last week and today, and thank you for all the work you've done for the families, especially hearing this morning that's all been pro bono, so good for you. I'm sure some very trying times, as you mentioned. Mr. Danson, you on behalf of the French and Mahaffey families have rejected the findings of the report on Paul Bernardo's transfer. You said, and I'll quote you, "We believe that Paul Bernardo should be in maximum security prison," end of quote, and that even if the transfer was done in accordance with all applicable laws and policies, those laws need to change. Can you expand on why you reject the findings of the report on Bernardo's?
I have have to stop you there, Mr. Shipley. We just have to suspend for 1 minute, Mr. Danson. We seem to be having an issue with our communication. Okay, we'll continue. Just to remind everyone to keep their earpieces away from the microphone when speaking. And I'm going to restart Mr. Shipley's time, please. 6 minutes, Mr. Shipley. Thank you, Mr. Danson, for your patience.
Thank you, Mr. Danson, and thank you, and sorry to the interpreters for that loud noise. It was loud out here, too. Not sure what that was. Mr. Danson, in order to save some time, I won't go back through exactly what all I was speaking of. I'll just paraphrase it a little shorter. Can you expand on why you reject the findings of the report on Bernardo's transfer and why you believe Paul Bernardo should be in maximum security prison for the rest of his life?
Well, I think that the criteria that they use, notwithstanding words to the contrary, do not differentiate between these kinds of offenders, someone like Paul Bernardo, which is very fact-specific, and the overwhelming majority of offenders. So I think there has to be an entirely different legislative and regulatory criteria for these individuals. And as I said in my opening, we must eliminate for these type of offenders the notion that the penitentiary sentence has to be the least restrictive. That is inconsistent with the sentencing principles, and it's inconsistent with what the trial judge, sentencing judge, had to say about Mr. Bernardo. And then, as I said a moment ago, this criteria that, well, because he's not representing a threat to the prison guards and other inmates, that's a justification for transferring him to medium security, or that he had fully integrated into a particular range that is very small. There just has to be a fundamental shift in establishing a separate criteria for Canada's most dangerous offenders, and don't put them in the mix of a criteria that applies to the overwhelming majority of offenders. And as I said, when you do that, and I mean, this one bit of information that I think I can impart to the committee with my 43 years of experience, if you do that, if the public knows that these type of offenders are being dealt with properly, then there will be an enormous view of the public to embrace all of the rehabilitation programs and assistance for offenders to make them productive when they eventually get out. But you can't apply that to people like Paul Bernardo.
Thank you. Building on that answer, Mr. Danson, in your response to Correctional Service Canada's report, you stated, and I'll quote once again, CSC's heavy reliance on Section 28 of the CCRA and the requirement that the choice of penitentiaries must be the least restrictive for the offender is misplaced, end of quote. Can you describe how the least restrictive principle being applied with a one-size-fits-all criteria is dangerous for public safety and re-victimizing for victims and their families?
Well, it's contrary to the facts. It's contrary to the facts that apply to this particular offender and similarly situated offenders. As I said, the least restrictive test really had currency with respect to offenders who were found not criminally responsible. It just doesn't apply to these kinds of offenders. As I say, it's fine if you apply it to the majority of offenders who have fixed sentences, and they're going to get out regardless. But it just has no application, and it's completely disconnected from the punishment principles of sentencing. And if one looks at 718 of the Criminal Code, in a case like Paul Bernardo, the preeminent principle is punishment. And that's completely inconsistent with those sentencing principles. It's got to be changed.
Thank you. You've spoke about the need for a different criterion to be applied to offenders who exhibit hallmarks of psychopathy. That's a tough one for me on a Monday morning, psychopathy. Can you expand on how an offender like Bernardo may be able to manipulate the test being applied to him to be granted a lower security classification?
Well, yeah, again, as I said in my opening, I mean, it's the evidence that was before Associate Chief Justice Lesage at the trial and at the dangerous offender application, and it's the same evidence that was, 25 years later and more before the parole board, is that this is the hallmark of psychopathy. They are deceptive, they're cunning, they're manipulative, and to have a criteria that doesn't take that into account and doesn't take into account what they learned from the various programs that are administrated to them, and what they learn from parole hearing to parole hearing is simply naive. And so therefore, I mean, thank God the majority of offenders in Canada serving federal penitentiary sentences are not psychopaths. But again, this is why you can't have one size fits all. You have to have an entirely different criteria for these particular types of offenders. It's critical.
Thank you. This will probably be my last question, Mr. Danson. You have mentioned many times that the parole process is harmful for the French and Mahaffey families, given that they need to testify and provide victim impact statements every 2 years, even though Paul Bernardo was serving an indeterminate sentence. Can you speak to the reforms you would like to see to ensure that the parole process for dangerous offenders with indeterminate sentences prioritizes victims' rights?
Well, I can tell you every time we get ready for a parole hearing, it is gut-wrenching for the families when we prepare their victim impact statements. And in the case of the French and Mahaffey family, we prepare very comprehensive victim impact statements. I think that, what happens is that as a general rule, parole hearings happen every 2 years. And the reality is for the families is that you finish one parole hearing and that 2 years goes by very fast. And it's very, very difficult to revisit this every 2 years, in my view. And actually, as a matter of law, they're actually entitled to a parole hearing on an annual basis once a year. Then the parole board has 6 months to process that, and as a matter of practice, it just works out to every 2 years. In my view, we'll use Paul Bernardo as an example. He's now had 2 parole hearings. But after the first parole hearing, maybe after the second parole hearing, there has to be a shift, particularly when there's a finding that he has no insight, no remorse.
Thank you, Mr. Danson. Thank you, Mr. Danson, and we'll continue, and hopefully you can pick up on those comments as we go to later round. Mr. Baldinelli, please, for 5 minutes.
Thank you, Chair, and thank you, Mr. Danson, for being here, and thank you for your steadfast advocacy and support of the French and Mahaffey families throughout all these years. Mr. Danson, you make reference to Justice Lesage in your opening, and who spoke of the likelihood of Bernardo being treated as remote in the extreme. Last week, Commissioner Ann Kelly was here in defending her decision, not only at the news conference, but she repeated last week that despite the fact that Bernardo has been transferred does not negate the fact that he is a psychopath. As well, last week, my Liberal colleague, Mr. McKinnon, also trying to defend this decision, was quoted as saying in speaking with Ms. Kelly, "I notice a common thread in questions from my Conservative colleagues. There seems to be still an impression that somehow the reclassification of Mr. Bernardo to medium security is some sort of a mitigation of his sentence. Can you tell me, are the pillows softer in medium security?" Mr. Danson, you said this decision sends the wrong message. It sanitizes the full brutality of the crimes, and I fully agree with you. I feel it brings, for my constituents at home and for the families, it brings the administration of our justice system and our correction system into disrepute. And they lead to the question that they simply ask is, who does the justice system serve? And I'm just wondering if you can comment on some of that.
Well, the glib comment about pillows is, if I shared that with the families, that would be gut-wrenching for them. That would be a shock to them to make light of this, with whether the pillows are softer or harder between maximum security and medium security. But it's to suggest that transferring to a medium security does not disconnect us from the fact that Bernardo is a psychopath. To me, that's just words. The fact of the matter is that he will have a lot more freedom and a lot more rights in the medium security. That's why I said earlier that the fact that the perimeter security may be the same between maximum security and medium is irrelevant to me. This is not a discussion as to whether Paul Bernardo is going to escape from a federal penitentiary, but he definitely has more rights. And the justification seems to be that there's more treatment programs when the evidence, even found by the parole board, is that he's not treatable. But it again, I apologize for repeating this, but it does not take into account the sheer brutality of what this man did, and that the punishment side of sentencing principles must prevail in this case. So, I mean, that's my short answer to your question.
You also mentioned there must be a law, a separate law. I've put forward a private member's bill 342 as well. A colleague of mine has actually put forward another one as well, C351, and that would require all court-ordered dangerous offenders and mass murderers be permanently assigned a maximum security classification. It also would repeal the Liberals' least restrictive environment standard for assigning inmates to prisons and restore the language of necessary restrictions. I thought perhaps you could comment on that.
Well, certainly as it relates to dangerous offender indeterminate designation, they should be in maximum security when we're talking about the most dangerous offenders. And as I say, we have to remember that criteria under the criminal code to be designated a dangerous offender is a very, very, very high standard, high criteria, which the Crown has to prove on medical evidence beyond a reasonable doubt. So there's our starting point. So of course, those type of people who when the prosecution can prove that criteria beyond a reasonable doubt should be in maximum security. We still have the parole board. I mean, this is really important, and I know this is really important when you go through the Supreme Court of Canada jurisprudence, even in the more recent Bissonnette decision. There has to be some escape route, in terms of we don't throw away the key forever. So you have to have a process, which is the parole hearing process, in place. But as long as that's in place, the rule should be that these people spend the rest of their lives in maximum security.
Thank you, Mr. Danson. And Chair, if we could, I'd like to seek unanimous consent that we could have another round of questionings.
C'est pas ce qu'on est en train de faire, là.
I felt like we were already in a second round, says Mr. Fortin.
Sorry? We're at third round, Mr. Fortin.
Un troisième. Ah bon?
A third, okay. Yeah, okay.
On est au deuxième tour.
I'm up to you. I'm just joining for today, so.
Since we only have an hour, I was hoping we could get unanimous consent for another round of questionings before the voting starts. So a third round.
Third round.
Yeah.
Mr. Julien? You good? Good. Okay, we'll continue on.
Can we move
Thank you,
now
Mr.
to
Bernali, Ms.
for
Thomas,
your
please,
questions?
for 5.
Thank you very much. Mr. Denton, thank you for your time today and having the opportunity or taking this opportunity to speak on behalf of the families. We very much appreciate that. My first question for you has to do with regard to the classification system and the reclassification of an inmate. Right now, the language that is used to determine that is an inmate is supposed to be in the, quote, least restrictive area, or the least restrictive measures are supposed to be applied. But the former language was most appropriate. And so I'm wondering if you can explain for us the difference in this use of language and what you would advise is needed.
Well, I prefer the former language, and to be clear and to be consistent, I don't have a problem with least restrictive as it relates to the majority of offenders with fixed sentences. So I know I'm repeating myself on that, but you cannot apply that criteria to Canada's most dangerous offenders. It has to be an entirely different criteria that has as its number one principle, which is punishment. And that's why I'm saying that, at least in the case of Paul Bernardo, we actually have 2 parole board findings about how dangerous he remains. And that, I mean, transferring someone who doesn't illustrate one iota of remorse or empathy or insight. So when you talk about least restrictive, what does that mean in a practical sense to these particular type of offenders? Why should someone who commits an offense, which, as I say, and thank God the videotapes are destroyed, if you just saw the cruelty, the sadistic brutality of these offenses, the horror. 30 years later, it still gets me emotionally. And to think that we're talking about the least restrictive punishment for this person, that has any reality. I mean, this is what Canadians will not tolerate. And that's what, but they will tolerate all kinds of progressive remedies and rehabilitation and programs for the majority, but not for people like this. So least restrictive is dangerous because it sanitizes the brutality of what's happened in cases like this.
Yeah. Thank you. Thank you for responding to that. One of the other comments that you made in your opening remarks, you asked the question, how can we allow something that is shocking and incomprehensible remain the law of this great country? And of course, in asking that question, you're referencing something that was said by the former public safety minister when he found out, or supposedly found out, that Mr. Bernardo was being transferred. He said that it was shocking and it was incomprehensible. Now, we later found out that actually that was misleading because he had known since March. He had known for quite some time before the transfer actually took place in June. But nevertheless, you make this statement that if it is, in fact, shocking and incomprehensible, then why would we allow that law to stay on the books? Mr. Denton, if you had to propose one change, the one that we should start with in order to make our system more robust and in favor of victims, what might that be?
That would be to establish legislatively a different criteria and regime for the Paul Bernardos of the world. That's where you start. And I'd be more than happy to help with particulars of that, but that's where it has to start. We've got to stop treating all offenders the same, using same criterias, and as I say, least restrictive. So at least restrictive for someone who commits a white collar crime, a nonviolent crime, is the same criteria we use for a sadistic psychopath. I mean, it just defies common sense. We have to have a separate regime for these individuals, obviously having due regard to constitutional criteria, but it must be the starting point for bringing some sense to this process.
Thank you. And in your expert opinion, do you believe that it's possible to make that differentiation in the law?
Oh, easy.
That's fine.
Easy.
Thank you very much.
Thank you, and thank you, Mr. Danson. We're going to move on to Mr. Baldinelli, please, for 5 minutes.
Thank you, Chair. And again, thank you, Mr. Danson. In earlier testimony, when you were speaking with my colleague, Ms. Thomas, excuse me, you were talking about legislation and changes that we could meet, and you talked about different criteria, a regime that is needed for the Paul Bernardos of the world, and that all inmates cannot be treated the same. And when she asked, would it be difficult to make that change? You indicated right away, you said it would be easy to make that type of change. So I was wondering if you could follow up. Do you have recommendations that you could share with us, to share with this committee on things that we could do to make some changes to improve our system?
Well, I'm happy to post this, submit some further submissions to answer that. But I think, I would start with, defining the Paul Bernardos of the world, these sexual psychopaths, and define what that is and what and the criteria that makes up a diagnosis of psychopathy. And then there's psychopathy, and then there's sexual sadistic psychopathy. Define it, and so you start there, and you separate them from all other offenders. And that's why I said earlier, if the Canadian public knew that these people are taken care of and they're safe from them and there's a rational criteria and system, they'll open up their arms for rehabilitation and treatment for all other kinds of offenders. So I mean, in the limited time, I can't do much more than that, but I think that you start off by defining this criteria and separating it, and then the recommendations flow from that.
If you could, perhaps you could submit something in writing to the committee to provide something more fulsome with regards to that. And then, again, thank you for that. Also, I just want to follow up. In our previous committee hearing, we had Benjamin Roebuck, the victim's ombudsman, and he mentions about the system that strikes the wrong balance between victims' rights and prisoners' privacy rights. And I was wondering, we had discussed the system, like, for example, the transfer, and whether or not, the victims' families had any input or could provide statements for consideration so that they're considered prior to a transfer ever being made. And I wonder if you have some thoughts on that.
Well, I agree with him, and I think that would be helpful because in this case, of course, there was absolutely no input. We weren't even asked. It was just a fait accompli. But again, I think that this whole notion of the transfer is that the problem I have is more fundamental, which is there really does have to be what I've characterized as a very different regime for these kinds of offenders, and because they're a minority of the federal inmate population. I don't think these should be administrative decisions. These may be something that the parole board can consider and give direction if certain criteria are met. But you have to know that the criteria that they're using right now is defective because, and I've talked to the commissioner as well, and I've expressed this, but how can you justify a transfer, as I've said repeatedly, when the parole board itself is determined based on all of the evidence that the offender is beyond treatment at this stage, has no remorse, no empathy, no insight. They applied a criteria that they say they followed properly that still nevertheless justified this transfer. Plus, I would repeat the earlier comments that I've made about the particular offense this person committed. That's why it's shocking and incomprehensible. That's how Canadians responded. Instinctively, it was shocking and incomprehensible. So clearly, and this is so hard for the families, and I think everybody on the committee, and I always try for the last 43 years on these issues to be nonpartisan because I think it is nonpartisan. We're protecting people from dangerous offenders. That we can allow something that the minister and the prime minister and other political leaders called shocking and incomprehensible, and then leave it. Like, what do I, as their counsel, what do I tell them? What's the answer to that question? There is no answer. I take all the political leaders at face value as being genuine and sincere when they talk about this being shocking and incomprehensible. And then we turn around and say, well, what are we going to do about it? Well, hopefully your committee will do something about it because it has to be changed.
That's a good
this
point.
Is the type of stuff.
Mr. Danson, that's a good point to end on. Thank you so much. Now we're moving on to Mr. Motz, please.
Thank you very much, Chair. Mr. Danson, thank you for being here. And as others have said, thank you for your continued advocacy for the families of these horrific crimes. A couple of questions. You had indicated in your opening remarks that something needs to change. There needs to be some change. There's the shock of this to society, to the Canadian public. Can you make any suggestions? Many people in my riding and across the country have suggested that the government has full right and authority to insert themselves in this. The minister can revoke this particular transfer. Is that something that the families would find to be of value to them, given your comments today?
Yeah, absolutely. I mean, I respect, and the families respect, that to a very large extent, the independence of Corrections Canada and the parole board. Parole board being different because it's a quasi-judicial tribunal, although some people would quarrel with that language. But when we come back to what we said earlier, that the prime minister and the minister and others are talking about shocking and incomprehensible decisions, and then say there's nothing we can do about that. I don't buy that. The buck stops, with the government. It stops with the minister. It stops with the prime minister. I mean, they're the ones who are answerable to the public, and if they see something that is rotten or something that is shocking and incomprehensible, absolutely, it would be the exception to the rule. But yes, they do need to insert themselves and take a leadership role and correct this.
I appreciate those comments. Also in line with the frequency of parole hearings, Mr. Danson, you've indicated the impact that this has negatively on families who deal with this. I know that from my own past experience in law enforcement. The frequency with which the current system handles parole hearings for designated dangerous offenders, is it something that you think the frequency should be extended so that it's not as every 2 years, it could be 5 or greater, especially for someone in this circumstance who has shown the incapacity to even be changed?
Absolutely. For these types of offenders, and as I said earlier, you have no idea how quickly 2 years goes. By the emotional trauma that the families go through to prepare their victim impact statements, to then attend at the hearings and give their victim impact statements, and then all of a sudden, within a year and a half, they're getting notice of the next parole hearing, which on average is every 2 years. It's without any change in circumstances for the offender. So, in my view, they're entitled to their parole hearing, and we're talking about these offenders like Paul Bernardo, not the majority. That it shouldn't be every 2 years. I've recommended anywhere between 5 and 7 years, and even at 7 years, I would propose in terms of any legislative amendments. Would be that if the offender or their case management team within Corrections Canada, that there's been a breakthrough medically or there's been a significant change in circumstances, that the offender can apply to the parole board to have an earlier hearing so that you have all the constitutional protections in place, the due process protections in place. But I think it should be, I do believe it should be 7 years for someone like Bernardo after their first hearing, but they have to have the opportunity to apply to the parole board to move that up if there's a change in circumstances. But in this case, and we've had 2 parole hearings for Bernardo, and there's been no change in circumstances. So why put the families through this every 2 years?
Thank you. I couldn't agree with you more. Mr. Danson, Public Safety Canada, Correctional Services Canada claimed that the Privacy Act placed significant limits on their capacity to share offender information. The former Minister of Public Safety repeated that excuse in the media. However, the Privacy Commissioner has directly rebuked that claim, noting that the Commissioner of Corrections can share information in exceptional circumstances. Can you discuss your opinion with respect to how personal information of the dangerous offenders that is normally protected under the Privacy Act should be handled to prioritize victims' rights over offenders' rights in these exceptional circumstances?
Right. Thank you. First of all, I reject that we require exceptional circumstances. That's not the law. That's not what the statute says. And I think that's important because Corrections Canada and the Parole Board is always looking for these exceptional circumstances. And the way they define exceptional circumstances would mean that there are no circumstances in which they would ever make disclosure of personal information of an offender, even though it's the personal information that's going to be disclosed at a public hearing. In the case of DAG, the Supreme Court of Canada says that the Access to Information Act and the Privacy Act have to be read in harmony. The purpose, and I just have it in front of me, the purpose of the Access to Information Act is the purpose of this act is to enhance the accountability and transparency of federal institutions in order to promote an open and democratic society and enable public debate on the conduct of those institutions. That's the legislative purpose. Then Section 19 of the Act takes you to the Privacy Act, and it's the Privacy Act that then says, and the exact language is that they can disclose the information if the head of the institution feels that the public interest in disclosure clearly outweighs any invasion of privacy that could result from the disclosure. So it's
To
clear
end
that
there.
if you're
Thank you,
going-
Mr. Danson.